To Chairman Hillier, Vice Chair Matthews, Ranking Member Isaacson, and members of the House Civil Justice Committee, thank you for this opportunity to provide proponent testimony on Senate Bill 237. My name is Gary Daniels. I'm here representing the ACLU of Ohio. As this committee has and will continue to hear from witnesses supporting SB 237, SLAPs, or strategic lawsuits against public participation, are lawsuits and counterclaims that hijack our judicial system to silence others. True, the ACLU of Ohio normally concerns itself with actions of government and government entities restricting the rights of people. However, the ramifications of twisting our courts to directly and indirectly limit speech is so concerning to us, we have long advocated for laws to end this practice. Our efforts have included testimony such as this, robust educational efforts about SLAPs and what they do, the filing of amicus briefs in courts with SLAPs before them for consideration, and direct legal representation of those negatively affected. SLAPs typically arise out of a power and financial imbalance between competing parties. A well-known scenario is grassroots activists speaking out about environmental, safety, or other concerns only to be sued or countersued for their advocacy. Those attacking the activists via the court system are unconcerned about final adjudication. Instead, they know the massive costs of litigation and legal defense act as a barrier against those without adequate financial resources to fight back and defend themselves. As a result, many stop speaking, advocating, and informing others about their concerns for fear of being sued. In other words, those with power and finances fully realize the First Amendment protects speech they do not like or want voiced. So they have found an end around via SLAPs. Of course, as this committee has heard and will hear from numerous others, SLAPs may and do arise in a variety of other contexts and situations. You'll hear more today. As instances of SLAPs increase and spread, the importance of legislation like SB 237 grows. Importantly, SB 237 strikes a balance, allowing courts to determine the merits of lawsuits and counterclaims with an expedited process before defendants bear significant costs in time, money, and stress to fend off such legal claims. But SB 237 also allows claims in the litigation process to proceed when there is merit. The ACLU of Ohio enthusiastically supports Senate Bill 237 and appreciates the leadership of its sponsors, Senators Gavarone and Manning. It is long past time for Ohio to join the majority of states with protections against SLAPs and further protect free speech. We hope this committee agrees, and we encourage your passage of SB 237. Thank you, Mr. Chairman.
Thank you. Any witnesses for Representative Daniels? Representative Stewart? Or excuse me, Gary Daniels, Representative Stewart. Do you have any questions?
Thank you, Mr. Chairman, and thanks for your testimony. I waited until a practitioner was here to kind of ask these questions because I want to make sure that everybody's fully appreciating, kind of the scope of this. I've described this bill as it is not making it any easier to defame people. It's not a license to commit defamation, but it is essentially saying if you have a meritorious defense to defamation, we're going to let you bring it earlier, resolve the case earlier, and keep your costs down. Am I in the ballpark?
Through the chair to Representative Stewart, that's true. I don't need to explain to those of you who are attorneys here how costly it is to defend yourself in court, even with lawsuits when there is merit, but particularly when there are ones that don't have merit. Again, the idea is not final adjudication. It's like, let's bankrupt and silence these people and file a lawsuit with maybe just a tiny little bit of merit so that, you don't get slapped back by the court and your law license is in jeopardy and so on and so forth. But yes, you're correct.
Quick follow-up.
Certainly.
Thank you. Appreciate that. And again, in practice of how this works, I'll let you jump in if I get this wrong, okay? But typically in a defamation case now, you may have a plaintiff comes forward and says, I believe that, John Q has defamed me. All right. And John Q may have the smoking gun that says, no, I didn't, because truth is a defense, and I've got the perfect document that says that what I said is true. But in our current civil rules, John Q can't attach that smoking gun piece of evidence to his motion to dismiss because that's outside the corners of the document. Right. So now he's got to do a motion for summary judgment. But we have Rule 56 that says, well, if you're doing summary judgment, you can delay your response, you get full discovery. We don't make people defend summary judgment motions until they've gone through discovery. Now we're doing depositions, et cetera, et cetera. And so we have delayed resolving a case that otherwise could have been finished in the first month for an extended period of time. Practically speaking, is that what you're seeing in these kind of cases?
Through the chair to Representative Stewart, I certainly can't answer for every single case, out there, of course. But yes, there are certain times in court cases, of course, you file certain briefs. That's when it's appropriate to do so. You can't do it before then. But as anybody knows who's been involved at any level of the legal process, and you're the one paying the attorneys, every brief filed, every conference call with the judges and the other parties, every motion you have to respond to, every phone call to your client, the meter keeps running, and attorneys are not cheap. And the people who file these slaps against other people fully know that. Again, success to them is not final adjudication, although I'm sure they would appreciate that when it comes down in their favor. The idea is to bankrupt and silence. And even just the thought out there that you can be sued, you don't even have to be sued, but the idea that you can be sued and find yourself in that position certainly prevents some people from speaking, advocating, what have you. And, this isn't an ideological thing. This isn't a partisan thing. Anybody can find themselves the subject of a slap at any given time for their speech or their advocacy.
Thank you.
Just one question, Mr. Daniels. You don't see the SLAP legislation infringing on insurance contracts or wrongful death actions, do you?
Chairman, I have to say I don't know enough about the intersection between those two areas where I feel I can be helpful to the committee.
Very good. Thank you for your testimony, sir.
Thank you.